Hi, it is Ron. I'm back. I thank you all for joining me again for the second installment of our discussion about litigation in the American system. We did a bit of an introduction in the first episode. Today I'm going to talk about the basics of how the legal system fits into our government. The United States government has three branches. This is not as common around the world as I think most of us expect. We're so used to hearing about it. But it is the way it was set up in our Constitution. Of course, the Constitution doesn't say anything about branches or three branches. It rather establishes the branches. Article 3 of the Constitution, which we will look at briefly, establishes the judicial branch. But we have to understand that government is by nature a law machine. Everything the government does is about law. The legislative branch makes laws. It is what we call Congress. The Senate is the upper house. It was meant to be a sort of reflection of the House of Lords. In the original scheme, each state legislature was supposed to send 2 senators to the United States Senate from that state. About 100 years ago, we switched to direct election of senators, which was the beginning of the end. And the House of Representatives, which at one time was meant to grow as the country grew until it just grew too much. It meant to be more like the House of Commons in the UK. In the British parliamentary system, it was capped at 435 members, and it is more representative, more of a direct democracy kind of situation. Congress enacts laws, and the president signs laws or signs bills to make them law. So Congress enacts proposed laws. They don't become law unless and until the executive, the president, signs it, or if he vetoes it, if his veto is overridden. That does lead us to the next branch, the executive branch. That's the President of the United States and all the agencies and departments that report to him, at least in theory. The whole concept of the administrative state and its metamorphosis into what has been called the deep state is that these agencies have long ago stopped being accountable to anyone, either the legislature that has created them and continues to fund them, or the chief executive who is putatively the boss of all of them. What we saw during the Trump administration is that these agencies hardly have any interest whatsoever in what the president tells them to do. They do what they want. This is a problem. This is a fundamental undermining of the Constitution. Talk a little bit more about that. And the third branch, the judicial branch, it's the one that I deal with on a more regular basis than any of the other two. The judicial branch is the courts. The courts interpret and apply the laws after the Constitution was ratified. A case called Marbury versus Madison held that the United States Supreme Court has the power to decide whether a law passed by Congress is constitutional. Now, there have been some scholars over the years that have said that this was a grave error, that this was not the intention of the founding fathers. But what is interesting to note at this point is that if the other components of the government at that time, if the legislature, if Congress found that objectionable, or they could have remedied the system that the Supreme Court maintained was the system by enacting a constitutional amendment, which, if the Supreme Court were wrong, presumably would have easily been ratified, stating that interpretation of the law is one thing, but declaring a law unconstitutional is not the province of the judiciary. What does it mean for the Constitution to limit the powers of the government, which it does throughout, if the ability to ascertain whether those limits have been breached is not subject to review by the judiciary? If not the judiciary, who then? It can't be the legislature itself. It's a little bit like the position that there is no afterworld. There's no judgment in the hereafter. God's law is true. This was the position after all of the Sadducees, right? God's law is true, but there's no reward or punishment. You just have to be a good servant of God and obey him. It's kind of a no accountability scenario. In my mind, doesn't make a lot of sense. It doesn't make a lot of sense to me either to criticize Marbury versus Madison, but much greater minds than mine. Oh, yes, there are such great minds. And the novelty here is not that they exist, but that I'm acknowledging that they exist. This is not going to be a constitutional law experience as such. It's going to be a lot more what they call high level than that. But it's the entire premise of how our system operates now. The extent to which judicial review has been abused by the courts is, of course, something that we've discussed many times in many different contexts, and perhaps it'll come up again. And after having told you that we will not be having, strictly speaking, a constitutional law course here, I do want to take a look at Article 3 of the Constitution, because that is where we learn about the courts, and that is our subject. Section 1 of Article 3 establishes that the Supreme Court is the only court required by the Constitution to exist, and that the judicial power is vested in the Supreme Court. That's an interesting terminology. And in such inferior courts as the Congress may from time to time ordain and establish, that the judges of these courts, whether Supreme Court judges or inferior court judges, and that includes now, by virtue of congressional action, the circuit courts of appeal and the United States district courts. There are also some other courts, I'm not going to deal with those today, that are both non-Article 3 courts, administrative law courts. We'll deal with that. Lifetime tenure and no reduction in salary. What's the condition? That judges hold their offices during good behavior, spelled British style. Let's remember that the Founding Fathers did in establishing the judicial power was based on the Anglo-Saxon judicial tradition. I'm not saying that the spelling necessarily leads to that conclusion, but it does remind us that the American legal system does not exist ex nihilo, that it was based on and meant to be an improvement on the judicial system that was in place in the British Empire. Well, Section 2 is rather longer. Federal courts have limited jurisdiction. And what those limits are is stated at length here, as you see in Section 2. We'll talk about those in more detail in the future. Congress has and has used the power to fill out what the federal courts can do. It has done so arguably to a fault. Now, that's all well and good with respect to the federal judiciary. But this is the Constitution of the United States of America. The states, each of them, came into the system and retained their own judicial systems. I'm sitting here in Foley Square at the court hearing that I was scheduled to go to was postponed. That happens, it's part of litigation. But it did seem to me that this setting would be a very good one for me to explain something that a lot of people are confused about, especially overseas, which is the difference between federal and state courts in the United States. As it happens, if you look behind me, you'll see the Civil Division of the New York State Court, the New York State Supreme Court, which is not really the Supreme Court. It is supreme compared to lesser courts in the New York State civil system, but that's New York State Court. And panning here a little bit further back, also with columns, that's the Southern District of New York and the Second Circuit Court of Appeals. Those are federal courts. These are two parallel courts that exist in the United States. They're everywhere. And you can find yourself in one, or sometimes both, in the course of a given case. Sometimes, like for example, in the Florida case that we talked about on my podcast with Andrew Esquire, and the Disney case, the same or very, very related issues can be litigated in both federal and state court, and that has happened to me. The real question is, which court's laws are you proceeding under, and sometimes which court has jurisdiction over you? Can you ever be in the same
court as a criminal defendant for the same conduct? The answer is yes. You can offend both sovereigns. Even though the Constitution prohibits double jeopardy, you can still be held responsible for violating, for example, a state law prohibiting assaults or terroristic conduct, and at the same time, federal civil rights laws for violating the civil rights of the person you assaulted or intimidated. So we can talk about that some more some other time, but again, I couldn't resist the setting, and plus I'm all dressed up with nowhere to go. There's one more thing I should add. One of the most common, or if not the most common, ways that a person could find himself in federal court in a civil case is under the concept of diversity jurisdiction. This isn't the kind of diversity that means everybody gets a trophy. Rather, it means that you have citizens or corporations of two different states on each side of the case. There has to be what's called complete diversity. There can't be any two that match up. The idea is, and this is something that is a gift from Congress, that historically people who were sort of out-of-towners didn't necessarily expect to be treated fairly by state courts in the out-of-town place where either they sued or were sued. So the thinking was, if we have access to the federal courts for those kinds of cases, involving judges who are not elected and who are appointed by the President of the United States, there's less likelihood of prejudice. This has become increasingly less relevant as a sociological phenomenon because, on the one hand, people have seen that there's plenty of hometown effect in federal courts as well, but also state courts are a lot fairer than they once were. People are not as alienated from each other just by virtue of being in different states.
Here we are in the United States with the big old federal government, 50 states and many, many territories, each of which have their own substantive law. And it has the potential to be very interesting to see which states' laws will apply. And there is actually something called jurisdictional arbitrage, by which lawyers map out what states' laws would be most favorable to apply and try to work out ways, sometimes it's called forum shopping, and that's what it is, to engineer the application of that state's laws to a pending dispute. That's part of the fun of what we do. So that covers pretty much the big picture. The source of the federal judicial legal system, some sense of how it incorporates the state systems, and each state, of course, has its own constitution, which establishes its own respective state courts. We're going to see how those interact as we go on, but we gave you a little bit of a sense of how the three branches interact, how the state and federal systems interact, and I would be surprised if no one has any questions coming out of this rather dense second lesson. But I thank you all for subscribing and listening.